a minute. I know we have a good sized group today. What I'm going to do is I'm going to mute everybody initially. And then if you want to unmute yourself, you can do that if you have a question. So I'll allow you to unmute yourself. I will definitely take questions in the chat. If you type your questions in the chat, be happy to take any questions there. And I will have kind of an open mic at the end if there's still questions at the end. So my goal today is really to give you education. My name is Bobby Fazy. I'm an estate and business planning attorney. And we're going to be talking about estate planning for about an hour and an hour and a half, depending on questions today. And so with that being said, I'll slowly get started. I will give you what I think is probably one of the bigger, one of the better things that you can take from today. And that is this handout that you received. And it says selecting and working with an estate planning attorney, right? And that should be showing up on your screen right now. And these are the questions that I would be asking an attorney, knowing what I know. And so everyone asks about price. That's a very important question, that's for sure. But there's about 14 other questions you should be asking. So an estate planning attorney to do your own due diligence. So we'll go through that today. And at the end, I'll check back in to see how I did with regard to that. So again, this is about education. Want to make sure you get a good education today with regard to the estate planning. So with that being said, I will jump in and go through the materials. So again, I'm Bobby Fazy. That's me in a suit. I rarely go in a suit because if I'm doing my job right, we're not going to court with regard to the family. We keep everything private. We're doing things in the back end side of things. We do estate and business planning. I would say 60 to 70% of our clients is estate planning, 30 to 40%, just depending on the mix, is business planning. We don't do personal injury. We're not family law attorneys. We don't do any of the other areas. This is our focus, okay? And you're going to find if we work together that I'm a very blunt attorney. Most estate plans just don't work, okay? And how would you know if your estate plan worked? Maybe a better question would be, when would you know, right? And be after you're gone. And so this is the things that you can do to check kind of the vitals of your plan to make sure you've got it in place. If you already have a plan or if you're looking for one. So the first thing I want you to be thinking about is, we're just thinking about estate planning today. So clear your mind. And I'm a visual learner. Okay. And hopefully this will communicate with you, is I use a snapshot test. So let's focus on estate planning for today. So I want you to think about the time after you've passed away and you're looking down from your cloud from above. All my clients look down, right? They don't look up. It's the alternative. And if money's going the way you thought they would be going and people doing what you thought they'd be doing, then that's generally a plan that works, okay? If money's not going where you thought it'd be going and not happening the way you thought it'd be doing, or people not doing what you thought they'd be doing, then that's probably a plan that didn't work, right? And so that's kind of like the basic, you probably have a picture of that. It might not be that sharp. My goal today is to give you a real clear picture of the issues that you need to be thinking about when it comes to that. There's some common traps that people fall into, okay? And I'm going to make sure that you understand the traps and the pitfalls and the issues so you can sidestep them. And one is kind of the document type of trap. What documents do I need? And you're focused on documents, okay, as the client or someone who's interested in estate planning. A will, a medical directive, a trust, right? If you're focusing on the documents, I would say don't focus on that. Yes, the documents are important, okay? But my analogy, first analogy I use is kind of if you ever seen the show, The Fixer-Uppers, Chip and Joanna, I love that show. If you've ever remodeled a house or ever renovated a house. So basically this couple, they go to different houses, right? And they remodel them. Joanna's the one that sits down with the clients, say, what's your vision? What's your goal? How do you want everything to kind of look and feel? And Chip is the carpenter who comes in with his tools, okay? And so that's the analogy I have for estate planning attorneys, is that does, you know, for that show, have you ever seen anybody, or if you ever renovated your house, anybody ask what tools Chip is using, right, to finish? They want to make, they're not asking about the tools, right? And so that's the lawyer's documents are just the various tools. They just want to know, hey, this kitchen looks like this, right? Or this bathroom feels and looks like this. They don't want to know how all of the tools that were involved getting in there. And so that's my analogy with the estate planning side is, when someone dies, right, the document is not going to jump off the shelf and do the work for you, okay? And so what I want to be, one of our missions in our firm, it's very clear, we all rally about this. It's not just me in the firm, we've got a team of 10, is that when we receive that call when someone passes away, we want to be able to say, everything's in good order. Just be with the family. When you're ready to deal with the legal side of things, schedule with the office, you're going to get priority. And we have a specific process to walk you through it, okay? They don't want to hear, I think everything's in pretty good order, we think, right? This is kind of an all or nothing type of deal. And the document is not, I mean, the documents are going to support the plan, but don't focus, you want to focus on what you want, okay? And so there's a lot of different documents and people get caught up in that. The other trap is the tax trap. Hey, there's no need for planning because I don't have a taxable estate. Okay, and you know, there's a lot of different issues with regard to taxes. That's not the only reason to do planning. But there's different issues with taxes. You might not have an estate tax. If you do, good for you. That's when you have a larger size estate. But a lot of people have retirement plans, okay? And retirement plans have beneficiary designations. And when you do beneficiary designations with a retirement plan, there's income tax issues, okay? So filling out those forms is estate planning. And there may be different options that you need to think about and how that works when you transfer those assets to the next generation, okay? So you need to be thinking about it. But they're just the landscape has changed, and who keeps on top of that stuff, right? Are you keeping on top of that, or is the attorney supposed to? And then the transfer trap. I just want to avoid probate. So probate is basically a government supervised audit of your affairs after you pass away, which is completely avoidable if you take the time to structure your affairs ahead of time. Okay, and so there's a lot of different ways you can avoid probate. That's good. That's an important goal, but I don't think that should be your only goal, but that's up to you to decide. My job is to show you my experience, give you the recommendations, and then you ultimately will make the decision. So these are typical traps, okay? You know, and so what's really missing is that just knowing all your options, getting an informed decision, having someone to counsel you through your options rather than just throw out some forms to you, you get some biographical data and boom, and without even, you know, and so that's something that, you know, is important to, I think, in the estate planning field. If you're just looking for documents, okay, then go to LegalZoom. All right, LegalZoom is a way to do, you don't have the attorney involved, or you have some, you know, random attorney out there, and they're just going to get biographical data, you get and you get the forms. So if that's what you're looking for, that's an option, and that may fit for some people. Okay, that's not what we're doing. Okay, but we'll show you the issue. So the snapshot that I find for most people, they don't know all their options. Today, I'm going to give you kind of a glimpse of what you really have out there. And hopefully that can focus that picture for you. Okay, that's the point of that slide. So let's begin with the basics. If you don't remember anything else today, and one of the first questions I would be asking an attorney is, how do you define estate planning? Okay, this is a basic question, right? I'm a fundamental person. And so the fundamentals on that is the definition I have for estate planning is, I want to control my property while I'm alive and well. A plan for me and my loved ones if I become disabled, right, mentally, can't handle my own affairs. And I want to give what I have to whom I want, when I want, in the way that I want. Okay, and I find a lot of people don't know there are different options in the way they can do that. All while assuring my wisdom is transferred along with the rest of my wealth. So yes, we try to set the bar high. If there's some non-material wealth values that we can pass on, let's do that as well. This is not a definition that's in Black's Law Dictionary or Webster's Dictionary. This is the definition for the National Network of Estate Planning Attorneys. I like this definition. I'm an instructor there. There's about 100 of us attorneys across the US that just focus on this. And so I think it really covers all the issues. And what I'm going to be talking about today is really just all these issues here. Which issue pertains to you is going to be, and which ones more you resonate with. It just depends on where you are in life, right? If you have minor children, there's going to be certain things that you want to take care of for minor children, right? And so that's really kind of where our counseling philosophy here that I put up. This is our planning pyramid. Basically, this planning pyramid lays out kind of visually how we work with clients, with the base of the pyramid being the most important issues, and we just work our way up. First, figure out what your situation is, what your hopes, fears, and goals are, and then the family, right? Do you have minor children or are they adult children, right? Whole host of different issues for minors than we have for adults. You got to think about guardians, trustees. Usually there's life insurance involved. What do you do with all that money? How do you leave instructions for that? What are the pros and cons of different issues? And if you have adult children, right? Age doesn't necessarily equal experience. How are they with money and the like? If they're married, how are their marriages, strong or shaky? Do they get along with one another? How about the spouses? How about your health, right? Are there health issues that we have to be concerned about? How is the spouse with finances? How are you with finances? Who pays the bills, right? When someone passes away, these are the logistical things that we need to make sure are clear. And usually when a spouse passes away, that's a traumatic enough of event right there. If you're saddling them with a whole bunch of legal and financial issues that they're not ready for, that just exacerbates the issue, right? So our goal is to make life a little easier during that time rather than be a mess, okay? So first is figure out the landscape, the family, and then if there's a special needs issue that we have to be concerned about, with regard to family members. So getting to know the lay of the land before we provide recommendations to preserve wealth, expand wealth, and save taxes, okay? And if you have a financial advisor that you work with, that is a great place where we can collaborate with them on helping preserve and expand wealth, because they're usually managing the money, right? And so I'm trying to explain the legal issues. And so one easy example is if someone has a stroke, do we have to blow through all of their retirement assets to take care of them? Well, if we haven't thought through this ahead of time, then yeah, all right? So this is where that can provide tremendous value. That's just one example with regard to that. And of course, taxes are important to save, okay? I've got a master's, right, in estate taxes and estate planning. So I know how to save the taxes, don't worry. Which one is the one that's gonna be right for you just depends on your specific situation, okay? That shouldn't drive the conversation. Your goals, your family, what you're trying to accomplish should drive it. And then we bring that. So the basic idea is you teach us about the family, we'll teach you about the law, and together we'll make the plan work. All right. I'm a bullet point person. So if you have an estate plan or looking for one, if you understand these 4 bullet points and can check them off and understand, yep, I got that covered, you've got a good plan. Okay. The last one has got some subparts to it. So the first one is, did you get good personalized counseling? And I spelt it with 2 L's. Or did you get word processing? And I spelt it with 2 L's so that, my counselor at law, that's what my license says, is that it has 2 L's. There's something more to me than just giving you some forms, right? So do you understand your plan? Do you know your options with regard to the plan? Do you know the consequences of your options? That's the thing, okay? And then do you have someone that's being proactive to look ahead? Watch out for this, watch out for that. And I'll give you examples, okay? And then number 2 is proper asset ownership. There's only 3 ways you can own your assets: your individual name, jointly, and by contract. That's it, okay? And so people just don't know the different consequences with regard to that. Contract one gets people confused a little bit. IRAs are contracts, TSP plans are contracts, annuities are contracts, life insurance policies are contracts, trusts are contracts, payable on death accounts are contracts. You need to understand that you have to get a great set of instructions, someone who personally counseled you, and make sure your assets are lined up the right way so your instructions actually apply and get the most amount, be most efficient transfer, least amount of taxes, the smoothest transfer, right? That's the trick, okay? Those 2 things are very important. And then number 3, let's have an agreement to take a look at this plan every so often because things change, right? So, wherever you are, the Virginia, we just had an election in Virginia, things are changing here, right? The laws are changing with the new administration. Your lives are changing. COVID changed things, right? So things change, and the plan needs to react and be able to be updated to conform with these changes. And I'll show you how we do that. Because we don't believe in an hourly billing model. I just find that people don't believe that you spent the time that you say you did. And even if you do, they don't think it's worth it. So I am not someone who's going to nickel and dime you. I'm going to say, here's the fee. If you want it, great. Okay. We're not going to drag anybody through the process. Then the control transfer process. This is really what it comes down to. Okay. So the control transfer process, and I'll get blunt again, is if you were to die today, how prepared is your family if something happened to you today? Right? That's what it comes down to. Would they know what to do, how to do it, and how to pay for it? Right? So that's the idea. Usually what happens is death occurs, the family stumbles into the attorney's office that they have not seen in years, or they even know the attorney or some attorney's office, and put some documents in front of them and say, now what? And the attorney and nothing's been updated. They don't have any kind of relationship, and they're charging hourly at this point, right? And things aren't sinking in because it's the grieving process, and things aren't even up to date. So it's so expensive, and people are like, why is it so expensive to do this? Because the process doesn't make any sense. Okay. I mean, we actually think that we do something 10, 15, 20 years ago that's going to actually stand the test of time, and it'll just magically update to where your family is at this point and all of your assets with the laws. That's not reality. Okay. And so the point of it is that we want to put the family in control. Okay. So let me show you the ways to plan out there. There's 5 options basically for you is what I see it. You can do no documents. I don't recommend that. And we can do a will and a POA. A POA stands for power of attorney. There's financial powers of attorneys that designate someone to manage your assets for your finances. And there's healthcare power of attorneys to designate your healthcare decisions to somebody. Okay. And there's a lot of different flavors of them. Okay. So you need to understand, I got a power of attorney. Oh, well, what kind of power of attorney do you have? A lot of people have what's called a general durable power of attorney. And a general durable power of attorney is like a blank check. Okay. It says, you are my financial, you can manage my finances, write checks for me, manage my investments, and it's effective immediately. Okay. And so they say it's durable because it will last through your, if you become disabled, it will still be legally effective. That may or may not be okay for you. Okay. Some people say that's a lot of control to get that gets into the wrong person's hands. I'm in trouble. Others say that's not an issue. So that's just make sure you understand that. There's something called a limited power of attorney or a springing power of attorney that only springs into legal existence only after you've been determined to be disabled, right? So which one do you like better? Okay. And maybe you say it doesn't matter, or I didn't know I knew that, right? So that's whose job is it to explain that to you. And then the will with a testamentary trust and power of attorney. Say with me, a last will and testament. A testamentary trust is one that's created after death. Okay. So that's one that's created after death with court oversight. So I don't know why anybody would want to have court oversight, but you can if you want to. So I'm not a big fan of those. Okay. So what happens is a lot of people with minor kids, and that's fine if you're just there in life. Okay. I'm just showing this is my experience on it. They don't have, it's a little bit more involved. It costs a little bit more to create a trust. Okay. And I think clients with minor kids should definitely have a trust for them because they need it more than people who are even older, because if something happens to them, you want the money to get paid to your trustee, the person that you trust to manage the money, not go through court, and you lay out your instructions in the trust that's outside of the court and say, this is how I want the money to be used. Thank you very much. I don't want them to apply for the court for every time they want to use money for it and spend accounting. But the wills, simple wills, they say, well, I don't have a lot. Well, so they decide to go with the will, but the consequences are greater if something does happen. Okay. A simple trust, I use simple trust to basically say these are ones that you might see through LegalZoom or things where there's not much counseling behind it. We've checked the boxes on, got it very basic, but there's no counseling. You don't understand how it works or what it does. And you don't even know if anything's titled right in with regard to it. And then I just say modern approach. So the modern approach is one where, there's the process that is in place. The documents are there to support the process for you. Which documents are right for you depends on your specific situation. There's some critical common themes that we find, at least with the current laws that are out there, that will utilize, will give your family the best options with regard to it. So there are trusts that are involved with the modern approach, but that's not the only thing. It's not just the document. It's also titling of the assets, making sure they're in the right place with regard to that. It's also making sure that the family is educated. What level of detail depends on the family, but if something happens, do they know what the heck to do, right? So they know who to call. And is it being updated to make sure it's conform to the law? So that's kind of what you're out there. That's your options. Which right is for you is your call, okay? Of course, I'm resonating toward the modern approach because that's just the most comprehensive. I think bare bones planning are the ones in the middle, and no documents is no planning. So here's your challenges, okay? So those are your options. Your challenges are mental disability. I would say this is probably our biggest challenge today. If you're younger, you're probably not thinking about this. If you're older, you may be thinking about this. Mental disability are things like if you have a stroke and can't manage your finances, or have dementia, Alzheimer causing dementia, a lot of Parkinson's causing some type of mental. So it's mental disability, because that challenge is higher, right? Because we have to be blunt. You're not deceased, right? Where we don't have to take care of your body anymore. Now, if you're here, right? Now we have to figure out what kind of care you're getting, where you're getting the care, where's the money coming from, who's giving you that care, right? And so if you haven't thought about this ahead of time, that just burdens the family, right? And so that's number one. Asset transfer on death. I don't want to have to go through court. I don't want to have to go through a bunch of hoops and make it a nightmare to get the assets to the right people on death, right? We want to have them structured in a way where it's seamless. Taxation, of course, let's minimize taxes to the greatest extent. And let's make sure that your personal planning goals are achieved. Like, I've got a special needs child, or I want to make sure the spouse is taken care of, they're protected, or the kids, or the like. So whatever your goals are, we'll give you some examples of that. Our firm uses a 3-step approach. This is different than a 2-step approach or the transactional approach. We're more of a relationship-based planning approach. So the first, we have 3 steps. We empower the design. So the design is kind of supercharged, where you have all your options laid out for you. So develop the plan with counseling-oriented planning partners. And so I said partners there, so that if you have a financial advisor or tax advisor that you trust, we want to make sure we're on the same page with them, and we collaborate with them, and that's going to provide more value to you. You want to empower your legacy. That's that maintenance side of things. Is let's have an agreement to update this. Commit yourself and your family to a formal maintenance and education program, so that when something does happen, we can empower the inheritance, secure appropriate assistance to transfer your wisdom along with the rest of your wealth. Okay, so it's not set it and forget it. It's set it. Let's stay on top of it a few hours each year, just to make sure things are on track, so that when something happens, we're in the best possible position. The family's in the best possible position to make this an easier process, right, down the line. So that's the idea. Okay, so let me teach you about some of the traps. So the transfer trap is probate. If your only goal is to avoid probate, I'll show you how to do that. I'll show you how to do it without any legal documents from an attorney, okay? But that's really short-sighted, but here's how you do it. My engineers love formulas. And so the first thing that you have to think about with probate is titling is how everything works with the estate planning. Okay, when you die, how people get access to your accounts is the way how things are titled. So if anything is titled in your individual name, just say that equals a will. Okay, and anything that's controlled by your will equals probate. And probate is that government audit of your affairs after death. All right, so here's how we can avoid that. You can title things as joint tenancy with right of survivorship, joint tenancy. And so what that means is, if you have a joint bank account or the like, think my lighting is not that good. Sorry, today's not. If you have a joint bank account or the like, let's say it's a husband, let's say it's a husband and wife situation, right? When one spouse passes away, the survivor will be able to obtain that asset. The way you do it is you take a death certificate to the bank. By operation of law, no probate is necessary. Okay. So that's okay. So that's good on number one. So when a husband, let's say in a married couple situation, great. There's no probate on the first death, right? What happens on the second death, right? And so all you're doing is just delaying the inevitable in that, you're just kicking the can down the road where, no, let's wait till the first spouse dies and let's, on top of all the grieving, let's saddle the surviving spouse with figuring out how to structure the estate after you're gone. Let's let them figure it out, right? That's not a good way to do it because we find that they're not usually prepared to do that, and it's just overwhelmed at that point. Let's take care of it up front and get it over with, right? Let's just set it up the right way up front. And if you say, oh, we'll just add somebody else on, be careful, okay? Because when you add somebody else onto your accounts as a joint account holder, you're taking on all their liability as well, okay? So if they get sued or they get divorced, you get all their problems too. It's not a good way to do the planning, okay? And you also give up a lot of protections that are out there. And I'll show you the protections in a later slide. You can do transfer on death accounts, okay? Transfer on death accounts is when you die, it's the bank's form or the custodian's form say, pay the money over here. That's another option there. Again, you're using somebody else's legal documents. I would not recommend that. And you're giving up protections. And then planning with the box is, what I mean by the box is those beneficiary designation forms in things like your IRAs, 401ks, TSP plans, and the like, right? Annuities, life insurance. Those, when you fill out those beneficiary designations, you're doing planning. And there's a lot of tax and legal consequences to it. So make sure you make the right call with regard to it, okay? 5-10 years ago, trusts were a great way to do the primary beneficiary. Now in a married couple situations, the spouse should be. But on a contingent beneficiary, the trust is better. Do you understand even know what I'm talking about, right? So the issue is what the tax laws are doing and what your goals are and what are your options for your family. It depends on the how big the IRA is, okay? We're not worried about trust if the IRA is small, but we are worried about trust if we have minors to deal with because minors can't inherit it directly. So we may have to worry about that, okay? All right, contrast with, this is what I mean by counseling, okay? This slide is important. These are what I find is typically missing in a lot of the estate planning out there, is that the people don't know what all their options are. I've already talked in that. The first one is catastrophic illness, remarriage protection, creditor protection. We'll talk about that, divorce protection, and then values promotion. So I already talked about disability, catastrophic illness protection, but just kind of the hammer the point home is if you did have that big illness towards the end of your life, stroke, Alzheimer's, or anything, that would put you not be able to manage your own financial affairs or not able to take care of yourself. Do you have an opinion whether you'd rather be taken care of at home or in a nursing home, or you don't care, right? And if you do have an opinion how you want to be taken care of at that point, where in your legal documents does it say that, right? And so people think that they've got it covered by having this advanced medical directive. And an advanced medical directive is like a healthcare power of attorney. It designates a healthcare agent to make decisions for you when you cannot communicate them to the doctor. It's blank, okay? It's boilerplate. It says, you can check me into the hospital. You can check me into a nursing home. You can bring me home and bring home care in for me. You decide, healthcare agent. And so I would say, if it's that important to you, where does it say what your views are? And if it's not important to you, you're not doing your family any favors by burdening that decision with them without having a conversation about it. So I find our role is to raise that discussion ahead of time. We have checklists to go through. And I think the conversation is more important. Of course, we want to have the legal documents to support it, but you need to have that conversation because healthcare decisions are not black and white. Okay. And so you need to make sure that, hey, if I'm in that situation, my goal is to put you or that healthcare agent in as good as a position as possible. This is what mom or dad would have wanted to do, right, in that situation. And then the financial side of things, people, that's a big control issue, right? When you're writing checks to the wrong people because you're mentally not there, and people are taking advantage of you, which we see a lot, not a lot with our clients, but we see in the field there. There's a lot of things that are going on, especially through the internet. And so the issue here is, on the financial side of things is our clients are big into control, and they want to be the one saying, Bobby, I want to just be the one making the decision when I'm not able to manage my finances. Unfortunately, you're disabled at that point. Okay. And so the next best thing I can give to you is I can give you control on how you give up control, if that communicates. So we talk about this ahead of time. We say, let's use a personalized definition of disability, which is, you have a healthcare, maybe your doctor, but also we want family members to be in charge, and that you pick, right? Or friends, or people that you trust. You can get second medical opinions or not. So those are, we call it a disability panel. And these are not people making healthcare decisions for you. Their only job is to determine whether you can effectively manage your financial affairs. All right. And so that's number one, is the when. When am I disabled, as you define it? And then if I am considered disabled, then who do I trust to take over and manage a checkbook, and what can they use the money for? Simple, right? But it's process. Process produces predictable results. So that's disability planning. Enough of that. Remarriage protection. I don't spend a lot of time on this. I mean, basically, remarriage protection is not about trust between married couples. But let's say I'll introduce you to my favorite cast of characters, Bill and Mary sample, right? Husband and wife, and they have 2 kids, and they have what's called the I love you wills. An I love you will is very common. When Bill dies, it says everything goes to Mary. When Mary dies, everything goes to Bill, right? If she predeceases to him. And then when they both are dead, everything goes down to the kids equally. Very common. So let's bring in remarriage protection issues. So I always knock off the husbands first, right? You can do whatever you want in your plan. So Bill dies, everything goes to Mary. And let's say Mary meets Bo, the tennis pro, and they fall in love, and she gets remarried. And let's say, and so Mary's will says everything goes down to the kids, but let's say Mary predeceases the new spouse, Bo, right? Let's say she dies, even though the will says everything goes down to the kids, does Bo have a legal right to those assets? In all 50 states, he does. He says, he could say, I don't care what the will says. I'm taking my statutory right. Every state has a different statutory right, election or augmented estate, just depending on your jurisdiction. But basically, so if you're in Virginia, Bo could say, I don't care what the will says. I'm taking my statutory 50%. So 50% is not on day one. It's over time. So it's a length of marriage type of deal. So if they've only been married for a year or two, it may be 20%, right? But it goes up to 50% pretty quickly. Once they're up to year 6 or 7, boom, you're at 50%. And so that's one issue, right? And so another issue you need to be considered, if you're taking notes, is title will trump the legal documents. What I mean by that is how you title things will trump how you're legal. So the will says for Mary's side, everything goes down to the kids. But if Mary has titled her accounts jointly, right, with Bo, they're not going to go through the will. They're going to go to the surviving spouse. They're going to go to the surviving joint tenant by operation of law. Another common mistake I see is usually spouses are beneficiaries on their IRAs. Remember that planning with the box, beneficiary designation form? Well, in a second marriage situation, if Mary leaves this IRA to Bo, even though the kids are listed in the will, Bo is getting the IRA, okay? And so my lights are turning off. Having a problem with my lights today. So if there was a way Bo could leave his assets to Mary, she could use it for whatever she wanted. But when she passed away, she had to give it down to the kids. I mean, it would have to go down to the kids. Is that something that's worth spending some time talking about, right? Is that counseling, word processing? What are the things that we're talking about? All right, creditor protection. This is probably the most important, or what a lot of clients are more in tune or more concerned about this. and there's a lot of myths with regard to creditor protection and asset protection. Okay, this is what I do kind of on a daily basis. So I'll teach you about asset protection and what you do get and what you don't get when it comes to trust planning and the like. All right, and so I use story. I'm going to use a story to explain this. I call it my school bus story, right? And so the school bus story, there's two assumptions. Let's say that I'm dead in the story and there's no creditor protection for me while I'm alive, okay? And so let's say I've died, and let's say I leave my assets to my wife, wife and kids, however we want to do it, right? Let's say I leave it to my wife. And let's say after I've passed away, my wife is all distraught. She's not paying attention. She runs a red light, bam, hits a school bus full of kids, horrible facts, right? Catastrophic creditor. She hates herself. The world's against her. Let's say one of the kids dies, right? And there's going to be a lawsuit, and it's going to wipe out anything that I left her, any insurance that I had, right? It's going to wipe out all of that. So the point of this story is just to show you the different ways that you can leave your assets to your loved ones. So you know your options, okay? Were you counseled, or is this some word process document? So first option is I could have done a simple will. I die, everything goes outright to my wife in a simple will. She hits a school bus, all those assets gone, right? Those are subject to her creditors. The second way I could have done it is I could have titled everything jointly. Remember I told you that joint tenancy with right of survivorship. So the house that was titled jointly, I die, she hits a school bus, can they put the lien on the house and foreclose on it? Yes. Or if they have a bank account, garnishment, right? So those things that are jointly held, no asset protection. The third way is by contract. Let's say I have a life insurance policy, not worth a lot while I'm alive, but I write my wife's name on the beneficiary designation form. It turns into $1 million. She puts it in her account. She hits a school bus, gone. Okay. The fourth way is by a trust. I call it a simple trust, right? Where it just says, okay, when I die, everything goes outright to my spouse. Same problem, goes outright into her account, subject to her creditors, gone. So let me do the planning again. Let me pull myself out of the grave, right? Do my planning again. Let's say I did it this way. Let's say I could have left my assets to my loved ones. In this situation, I'm just using my spouse as the example. She could use the assets for whatever she wanted, but if she hit the school bus, it's protected from her later creditors. Let me say that one again, okay? Because people don't realize they have this option. You can leave it to them. They can use it for what they want, but if they hit the school bus, protected from their later creditors. So I'm going to ask you a question. Remember that definition of estate planning. I want you to connect the dots here. Remember when I talked about one of the parts of the definition is I want to give what I have to whom I want, when I want, in the way that I want. So how many of you would like to leave your assets to your loved ones that way, protected from their later creditors? And how many of you have been asked that question before? Is that counseling? Is that word processing? Whose job is that to do that? Okay. So that's the point of it is you just need to have someone who can help you, give you your options. I'm not saying this is right for everybody, but most people like that. Okay. We live in a litigious society and there's a way to do that. So let me back up because I want to make sure you understand this because there's a lot of myths with trust planning. Okay. Let me introduce you to my little trust box. So this is my little trust box. Think of a trust as nothing more than a box. Okay. It's basically a contract. And we're stacking the contract in your favor ahead of time. You're all three parties initially. You're the trust maker. I'm creating the trust. You're the trustee. I'm managing it. I'm holding it. And you're the beneficiary, right? You're receiving the benefit. So a revocable trust, okay, is what typical planning is basic planning people do. And they have is like an open box. Okay. There's a lot of benefits for it, but I'm just focusing on the creditor protection. And so a lot of people think a revocable trust will give them asset protection. No. Remember in the story, when I'm alive, no asset protection for me. So you can get in and out of your assets out of the box while you're alive, right? With a revocable trust, your creditors can as well. So if you don't pay your mortgage or your bills, those assets in the trust are not magically protected, okay? But when you die, you can put the lid over it and say, this is my hard-earned wealth for my spouse or for my kids. It's not for their ex-spouses. It's not for their creditors. This is my money for them. This is the rules. With their money, you can do what you want with it. You get it? That's how trust law works if it's done right. And that's how that's creditor protection when it comes to a revocable trust, and it turns into an irrevocable trust at death. And you say, this is the rules. And you say, it's for them, not for their creditors. And a revocable living trust is a good way to do good basic planning. So some of my clients say, Bobby, that's great. For them, can I get asset protection? Can I get protection from creditors myself? You can. It's beyond the scope of today, but let me just let you understand. If someone understands how to work with trusts, right, then you just create that type of trust before you die, okay? But that's more advanced planning, okay? So some of my clients who are worried, that are in high-risk professions like to do more of that advanced planning, okay? Those are options. That's beyond the scope of today. If you have a larger estate size, you can avoid estate taxes, a lot of estate taxes by doing those types of structures as well. Again, beyond the scope, it's just there, all right? We can do that, but I'm just giving you the basics. Today's a 101 day. If you're on the other end of the spectrum where you're worried about, hey, if I get a stroke, I don't have a lot of wealth there with the cost of care these days, monthly, right, can range anywhere from, if you have a long-term care issue, could cost anywhere from $5,000 a month. I've seen it as high as $20,000 a month, right, for care, blowing through people's retirements. Okay, that's what happened to my dad's plan. I didn't do his plan. That's why I got into this business. He had Parkinson's. We had home care for him, and we blew through his retirement, and it was really tough on my mom, right? And so if you don't have a lot to lose, it's even more important that you've thought through those issues before, because there's not much wiggle room, right? And so that's really important. And that's more on knowing your long-term care options, understanding how Medicaid works and the like. Again, beyond the scope of today, but that's kind of that's the range of what I mean by creditor protection. Creditors can be in the form of, judgment creditors for, liability concerns, or even the government for healthcare services, right? Long-term care services. So there's a lot of creditors in different ways, and predators of the world, right? That people who are out there that are not the nicest of people. Okay, so that's creditor protection. Divorce protection, I don't spend too much time on this one. It's just, how would you like to assure that the asset that you leave to your beneficiaries stays with them, right? And doesn't go with the new outlaw, if that communicates. And then values promotion, I used a babysitter story. So if any of you have kids and hired a babysitter, I've got a 5-year-old. And so the idea is, like, when you're trying to go out for you're going out for a dinner and a show, and you hire your first babysitter, you're just going out for one evening, right? And when the babysitter comes over, giving all these instructions, she's going to want to stay up late. If you read a book, read every page, because if you skip a page, she knows. I don't know how she knows, right? Make sure she brushes her teeth. These are our neighbors' information. We're going to be here. Here's our cell phone information, right? All these instructions, and we're just going away for just one evening for a dinner and a show. And so my point is simple. Would you agree we leave more instructions there than we even think about leaving in our estate plans when we're going away for a lifetime, right? And it's not like it's just, here's a piece of paper, give us your values. We've done this before. And there's certain places where this is the best place where you're giving this gift, to put some points there. So there's certain places where you can identify, record, and memorialize your legacy with different checklists or questions that can elicit those. So those are empowering your design. And so my point of it is, here are your options. And it's kind of like going to the eye doctor. I just went to the eye doctor yesterday. So it's called a phoropter. They say, which one you like, which one's better, 1 or 2? Even though I can never figure out which one's better. But the idea is, which one, I'll narrow it down to 2 or 3 based on your goals. Here are your options. Which one do you like better, right? And we'll talk through that. And we co-create the plan, all right? So it's not just me telling you this. I'll narrow it down for you, but ultimately we're going to work together on it. So that's what I mean by empowering the design, is really digging into the issues the right way, thoroughly upfront, so we do it the right way, right? Don't shortcut that. And then empowering the legacy, that's the maintenance side of thing. And the very easiest thing that I can show you on the maintenance side is explaining explaining how our just giving you the bullet points of our maintenance plan. So let me go ahead and make sure I'm sharing my screen properly. Okay, so this screen right here gives you bullet points of our maintenance plan. All right, and so for typical clients that are, we don't have any advanced planning or advanced tax issues and the like, our base planning, what we charge annually is $725 a year, optional to be on our maintenance plan. So what do you get for that 725 bucks? I'm not going to nickel and dime you for phone calls, emails, faxes. You got a question, call us. We have a specific way to answer the questions. We have phone appointments, we get scheduled. Tell us what the issues ahead of time. We're going to knock it out. Okay. Copies, word processing amendments, right? So once we get the plan set up, if someone moves or their name changed, that's word processing. I'm not going to nickel and dime you for that. We have a specific process that's all included. Okay. Every year, this is, I think, one of the most important ones, is we're going to do an annual funding double check. Okay. I'm teaching you today. So the goal today is to give you the kind of the terminology. You need to understand what funding means if you were interested in trust planning. Okay. So if we're dealing with trust planning, here's the things that you have to be thinking about. And this is our asset report. So if you have a trust, think about the trust as this box. Funding, I don't know why attorneys use this word, but funding basically means putting all of your assets in the trust box, okay? There's some exceptions, retirement plans, I'll go through the exceptions, but mainly everything, okay, with some exceptions that we'll bring up. And the reason why, it's really just retitling all the assets. That's the detail work, okay? That's the follow-up that I find gets missed and is the most common pitfall with people who have trusts. Because the first question I ask them is, okay, you got a trust, I'll review it, has it been funded yet? And they look at me like, what does that mean? It needs to be fully funded to make it work, because it's an all or nothing game with a trust. Is that if we get everything in there, you pass away, you pass the box on to the next person in line. We do avoid the court process. There's still an administration, but it's all private. We're not on the court schedule. We're not going through probate. You leave one asset out, okay? The way that works, I'll tell you some more legal technical. There's what's called a typical planning strategy. Is you have your revocable trust and there'll be a pour over will. The pour over will sounds nice. I call it the legal pooper scooper, right? Cleans up your mess after you're dead. It says, if I forgot to put something in my trust when I should have during my lifetime, scoop it up and pour it in after my death. Great. It'll get to the trust after death eventually. The problem is we stop off at the probate court. So why did we do the trust? To avoid probate, every asset that you leave out has to be probated. All right, so that's the problem with those. And so this asset report, and that's the detail work, right? So when you're comparing apples to apples, it's not just the documents, that's just part of it. It's making sure the assets are coordinated. This is what this is a sample report. A check mark, we'll send this to you every year. We upload it to your portal. Check mark means we've got a piece of paper in the pile verified. It's in RLT, stands for Irrevocable Living Trust. And you give us the new values, okay? And if you sold something, you cross it out. And I don't have to play Sherlock Holmes to go find everything if something happens to you, right? When you pass away, everything is in one report. I hit a button, I know who to contact, and that's the detail stuff, the asset transfer, and get it to the right people. Cuts a tremendous amount of time and expense off of the administration. Can't tell you how many times people come to me, there's a death, they have no idea where things are at from people, right? We got it all right there. If it's not checked off, we're going to send you a note like, why, we're looking for this document. Have you received it yet? Because a lot of times we will submit the forms, but they're not going to send us the verification. So I want to have everything verified. And then if you have new assets, you add those in on the back end so that we're not missing anything. Okay. That's annual funding double check and ongoing funding support, meaning you're going to open up a new investment account or buy a piece of real estate. We'll help you get it titled right from day one the right way. That's part of the deal, okay? Family meeting. In year one, it's no additional charge. We'll go over the plan as high level or as detailed as you want with whoever you want. And just to make sure that they know, who we are, what to do, and that main point. And then every year we'll do an annual group client meeting. Okay, so we've got about 270 families on our maintenance plan. We don't do 275 annual meetings. Okay, there's no way I can have $725 cover all that and do that, right? So we do group meetings, and we do them in January and February, and they're through Zoom, and it's more of a big picture meeting where we're going over what the laws are, the state of the laws. So there's going to be some changes, right, in the laws at the end of this year. They're arguing about it right now. There was changes last year. So what I do is I analyze them and tell you what you need to know and how that impacts you with your planning as it relates to your estate plan. Okay, things that dealing with retirement plans and the like. Okay, and so I explain that what's going on with the laws, what's out there. Digital assets seem to be is a very big area where, okay, whoever is all your financial accounts, but what about all your online accounts, right? Your Amazon account, your photos, those things. Do they get shut down or they get transferred? Does anybody get access to those things? Do you have a domain name to be thinking about? So think about how many usernames and passwords that you have, right? Things change. So that meeting is about, here's what the laws are and here's what you need to know. Here's what's going on with the law firm. Okay, so you know who we keep adding team members right now. And just basically, checking in with that. So that's every year. And then every 3 years, we'll do a group document update. So this is a wholesale these are updates of your trusts and the like. And we have a specific process to do this, where we have an executive summary. We call it your estate planning review worksheet. And it's an easy way to communicate with your law firm the changes. Yes, I want to change. Here's the bullet points or the cliff notes of your plan, your beneficiaries. I want to make a change, or I don't want to change, right? Or I want to change my trustee. And this is a great way to just, if you wanted to make an amendment, fill out the form, upload it to your portal, bam, 30 days, we get the amendment done. But every 3 years on the clock, we're going to send the report out, and we have a very strong process to update them in group format. Okay, if you don't want to do the group format, that's fine. You can do individual, but that's going to cost an additional fee for that. Okay, most people, 90% of our people, just do it through the group side of things. On the digital, we're getting the laws are changing on the digital side. We are digital notaries, and with COVID, we made some adjustments. So there are abilities to do some digital notarization. We're still on the beginning phases of that, but that's, in 5 years, that's going to be probably a normal thing as well, right? So things change. So this is your will, your guardians, if you have kids, description. So this is an easy report to go through and update things. And so when you think about it, right, it's just about open lines of communication. If I know where your assets are, the asset report, and I have your latest set of instructions, we're miles ahead, right? So we got that, it's updated consistently. Group educational programs, the number one program that people come to, I'm doing it this month. I do it every year, the Saturday before Thanksgiving. I call it Nuts and Bolts 1. It's basically goes through the 911 information that you need to know. Someone dies, right? What's the first three things that you need to do? What are the checklists, frequently asked questions, and the like? So all of our clients, they would go to, I put the recording, if you can't make it we'll do it Zoom this year. I used to do it live. We'll hope to get it back to doing live again, but we're doing a Zoom. But we also put it on our website for those who couldn't make it live. Live, you can ask questions for me. And so in our website area, there's an area where it says required training or 911 info for beneficiaries. I just want people to watch the latest video or come to the latest education program once every 5 years, so that they know something happens to mom or dad. We are not starting all over, right? And we're not coming out of left field to go through it. So I have a video that goes through that. I have videos on different things, but that's something that very easy, right? We go through the 4 steps, just know those issues, and that's important. Also, while I'm here, as part of the maintenance plan, you'll have DocuBank access. So DocuBank is a card that you will receive storing your medical directives, because typically you're not keeping your medical directives in your back pocket when you're driving if you get into an accident. I tell my clients, put this card, sandwich it between your driver's license and your health insurance card, because you get into an accident, go to the hospital, they're going to want to know who you are and if you can pay. And this document says my directives are here. Dial this number, or it'll get, or they can just download. There's a information here where you can download it right over the web. It'll get faxed to you 24 hours a day, 365 days out of the year. It'll go directly to the hospital. So it's a nice service, and you just have access directly with with regard to the asset. So you have a member number and PIN number right on there. There's nothing specific other than your medical directives, right? You get that. There's a lot of different things that you can get from it. Member number login. Okay, so. Oh, my member number was wrong. That was for my daughter. I took the wrong directive. Hold on. I'll show you. This is my daughter's one. And so this is, if you have a child care, if you have minors, then you can have a child care power of attorney for them, for the kids. I have to do this now. Okay, hold on. Update documents. I'm failing miserably on this part, but it's very easy to access. So I'll move on to this one. I didn't bring the right card with me, so shame on me. I put the wrong card in my wallet. So DocuBank access is one of the things. That's the membership. That's the medical directives online. The group educational programs I went through as well. So that's the $725, and that's for all of the maintenance plan services. All right. Make sure I'm on the right screen. Okay. So that's what the 3 types of changes to every estate plan: changes in your personal situation, changes in the law, and changes even to the estate planning attorney's learning. Okay. Make sure I go to that. Okay. All right. So once again, the Empowered Legacy Program, the items that are part of the updating or maintenance is every year, we'll get your asset review report. We'll have your estate plan review worksheet. We'll do the annual client meeting. We will do the client update program. And then we have education programs kind of sprinkled in between. And that is for just different things. The main one that people go to, we have the biggest attendance, is the one on the 911 program, where I go through what happens when someone passes away. The other ones that people come to a lot, I mean, it just depends on what your specific situation is. So if you have large retirement plans, they passed a law called the Secure Act in 2019 that affected how the retirement plans work at death. So we did a specific program for that, and we recorded it, put it up on our website. So you get the idea, right? On different topics and issues that are relevant to you, we'll do that on a consistent basis. All right, so we set the plan up, we maintain the plan. The third step of the process is securing appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So now, I don't know what appropriate assistance looks like to you, but for us, it's about controlling costs. That'll give you full disclosure of the costs as well, and that will hopefully give you true peace of mind. So I am very transparent on the cost. So we will talk about costs right now and how you have to think about costs in the estate planning world. And this is my advice to you. So you'll see these items. Okay. So the way you control costs is, number one, is by full funding. Full funding, I told you about that already, is if you've got everything title right inside of the trust, then we don't have to go through court after death. So if I have a fully funded trust, that will make my life easier because I don't have to go fill out the court silly forms. And then that makes the costs go down, and that should translate into a cost savings for you, right? So number one, Fully funded trust will control costs. Number two, proactive trustee or beneficiary training, right? That's our education programs and what I'm doing this month. So that when something happens to you, we're not coming out of left field to figure all this out. They know, okay, we've got the basic, we know who to call. We know there's a process, stick to the process. We're good. We've done a 51, 52 administrations, right? And so we've done this before. That's what we do. We happen to be very uniquely understand. We know how to go all the way to the end. We're just not setting it up and forgetting it, right? The idea is that we're following through and we will follow it to the end. And then a proactive engagement approach. If you're on our maintenance plan when you pass, we'll have an engagement agreement that we say, we'll agree to do the administration at these rates, at predetermined rates, lower rates than the market rate. But your family does not have to hire us. Okay, I can't ethically, as an attorney, I can't ethically lock them in. The successors would have to hire us. They say, okay, we want to do it. And then, a lot of people want us to write us into the plan to do it. We can't do that. But all we can say is we'll do it for this because they were on the maintenance. So if you want to do it, we're good. So that's how, that's kind of give you an idea of controlling costs. Okay. Fully funded, have some education ahead of time, have the engagement agreements already negotiated ahead. So it's set, okay? Whether they want to go forward on it, that's up to them, okay? And just to hammer the point home on funding is we're moving all of your assets in there. Now, one asset I want to make sure you don't leave here thinking, hey, we got to put everything in the trust, is your retirement plans, okay? When you are a participant in your own retirement plan, a 401k, an IRA, TSP plans, those if we actually change the ownership and put it in your trust, that's a distribution, okay? And when you have a distribution from a retirement plan, that's taxable. And I don't want to do that. I want to minimize your taxes, okay? So if you change your retirement plan to your trust, that would say, they're saying, oh, they took a full distribution of the retirement plan, pay the tax now. No. Okay, we look at the beneficiary designations on the retirement plan. And then we also look, because there could be a trust there, right, in the beneficiary designation. And then we also look at, hey, if you become disabled, is there a financial power of attorney that the custodian has, that Fidelity or the Morgan Stanley's or the other different financial custodians in the world, do they have a specific one that they use, or will they take our question? Okay, and so that's or they will take our power of attorney form. So that's the issue there. So that's funding. Okay, so let's go into fees. Factors of overall cost. So you have a setup cost, the cost of the initial counseling and the documents. Most people are shopping just there, okay? Be a good consumer, look at the whole thing. See about also the cost of updating the plan or failing to update. And the cost after death. No one asks about that, but that's really where the back end loaded. So I'm going to start. I'm a Stephen Covey fan. I'll begin with the end in mind. And so I'm going to start with the fees after death that you should be aware of. Okay. So probably more than you ever want to know, but here you go. So when you die, and I just pulled out the fee schedules for Fairfax County here. This is if you have a will. I want to do a will. Will, remember, equals probate. Okay. So if you go through the probate, the way that it works, as far as, and this is what it costs to do the administration of the estate. These are ranges. I can't tell you exactly what, but this is what the guidelines are for the court. So if you fall within these guidelines, right, you're going to be okay as an attorney to do the administration. So usually what happens is on a will, they name a family member as executor. The executor has no idea what they're doing. They hire an attorney and the attorneys are charging these rates. Okay. And so Virginia, this is just Virginia's. I have Maryland in here, and I got some other jurisdictions. I'll just give you an idea. I love how they say in quotes, is there reasonable compensation? What's reasonable compensation to do an administration? So while the assets are tied up in probate, let's say there's $1 million, right? Let's say it's throwing off, $50,000 a year of income. I don't know. I'm not saying $1 million would do that, but that's a 5% return. But while the assets are tied up, 5% of the income receipts is a reasonable fee. And then the principal, the underlying $1 million that goes through probate, the first $400,000, 5% can be charged on that. That's $20,000. the next 300,000, 4%, that's 12,000. And then the next 300,000, 3%. Okay, this is the fine print that no one shows you. And those the fees are pretty big, right? And so not all attorneys will charge it. Some will charge more, some will charge less. It depends on your specific situation. Go figure. If your estate is more out of whack or not unorganized, it's going to be more expenses. Loudoun County is the same as all the counties in Virginia are the same. If you're a Maryland resident, Maryland has, I have a Maryland resident that is 3.6%. 3.6% of the excess over the 20,000 of the gross estate. So Maryland's 3%, 3.6%. Okay. And then Florida is as follows. So trustees, attorneys' fees. So Florida, and the only reason why I'm showing you Florida is not because I assume you are Florida residents or in Florida. Basically, Florida gives you what is one of the prime examples of what an attorney can charge to do a trust administration. So really big difference here, right? Probate, wills. Okay, what if we avoid we don't want to go through probate? What if we do the trust, Bobby, right? So this is important, okay? So Florida being, and so Florida has a strong senior lobby, right? A lot of people retire in Florida. Some people call it God's waiting room. So Florida is one of the few states that actually passed a cap on what an attorney can charge to do a trust administration. Okay, so that is not many states. So I'm just giving you what's kind of the market rate that's out there for what. And so they are a consumer protection state. So they said, look, attorneys, you can't charge more than this. The other teaching point for this is that people think that if you do a trust, that there's no administration at death. That is a myth. Okay. To be blunt, death is a major life event, right? Every one of your assets, every one of your accounts online, everything, any of your debts, everything has got to be closure on it, right? Got to be tied up in a little bow. So everything that you have to be, there has to be some type of closure on it, transferred or shut down, right? So it's, and taxes, there's taxes to be worried about too, right? And debts and things like that. So there's going to be an administration. It's just a matter of if you're on the court schedule or keeping it private. My preference is keep it private. That's going to be cheaper. And this tells you, Florida says, here's the market rate, people. If you go over this, we got a problem, okay? And it's paragraph 3 is what they say. I'll boil it down for you. They basically say an attorney can charge 75% of what they could have charged on a normal probate, and that's a reasonable fee for a trust administration. And so the probate schedules for Florida I gave to you are a percentage scale, just like Virginia, just like Maryland. They're just different. They're lower, so that you see. So if you have an estate between 100 and 900,000, 3% is what that would be on the probate. The trust administration would be 75% of that, or a 25% discount. Okay. If you have an estate between 1 to 3 million, 2.5%. Probably more than you ever wanted to know about what happens after death. But I'm showing you, okay, how it works after death. And so let me show you how we charge. I'm going to give you ranges, okay? These are not, I can't tell you exactly what I would charge you until I actually know your situation. And know your specific situation. So I'll tell you one thing, I'm not going to charge you anything until we know exactly what your goals are, where you're at. And we would say, here's what we would do it for. And we decide right there. But let me show you. We have a fixed and variable option. And most people take the fixed option. And so let me start with after death. So that's this 1.25%. There's a setup, maintenance, and after death. So after you pass away, if your family hires us, we can't lock them in, but we will agree to do the administration at 1.25% of the size of your net estate as a cap, okay? You just saw 2, 3, 4, 5%. We're going to be lower because I'm not coming out of left field. I've got this maintenance plan. That's where we update the family, right? Where we have a fully funded trust. If I don't have to go through probate, that makes my job easier. That translates into a cost savings. If I have an educated family that knew the process, followed it, we've done it again and again, that's going to make my job easier. That's going to translate into a cost savings. If I have updated legal documents, no more than 3 years old, that's going to make my job easier and translate into a cost saving. If I have a planning partner, a financial advisor, or like our back offices are in sync, we can set up the inherited IRAs or the trust accounts. Makes my job easier. That translates into a cost savings. So that's where that $725 a year comes in. It's optional, okay? But if you're not on the maintenance plan, then I can give you the administration rate at the pass. To enroll in our maintenance plan in year one, we charge a little bit more. We charge $1,000. And the reason why we charge $1,000 for year one is we're verifying all of the titling that we did on the upfront. Okay, so upfront to set up the plan, we'll title everything, but we need to verify it, because I find that when we submit things to financial institutions, sometimes they don't process them correctly. So Jenny Oliver, our funding coordinator, she has a high standard, is that we have to give a piece of paper in the file for every asset before we give a check mark. Okay, so that's tracking everything down for year one to make sure everything is in there, and tracking you down for that stuff, because they usually send it to you all. For the setup of the plan, okay, and this is for non-taxable estates, basic, planning for our clients. The majority of our clients are there. If you have a taxable estate, that's great, but that's separate. We'll charge 1/2 of 1% on the size of your net estate, subject to a minimum and a maximum. Our minimum fee is $4,000. Our maximum fee is $12,500. Where you land on that depends on your goals, your assets, what you're trying to accomplish. Again, that is laid out in a specific engagement letter ahead of time. If that is too high for you, we can do a variable option, which is lower upfront. Our minimum is still $4,000. Our maximum there is $9,500. The difference is on death, we're going to charge 2% rather than 1.25%. Okay. And that's the first tax coupon. I haven't talked about taxes too much, but from an estate tax side of things, I'll be real brief about it. And if you have a tax issue, we dive into that later if you have a question about it. But basically, right now, you can die from a federal estate tax. You can die with up to $11.7 million before any federal estate tax is due. And if you're a married couple and there's a decent attorney, you can double that coupon. I call them coupons. That's what they're fighting over in Congress right now. That 11.7 million is scheduled to go down to 5 million automatically on January 1, 2026. And that may still be more than you have, right? But that's a big difference between 5 and 11 million. That's going down January 1 of 2026. They're fighting over, hey, let's do that next year. Okay, so that's what they're arguing about right now. Okay, so that's that. That's what's in it for you. On the backside is what's in it for me. This is my business model. Okay, I'm very transparent. So the counseling and design fee is we're not what's called a will mill. I'm not looking for 1,000 clients this year. I'm looking for 60. So we do less clients, more custom plans. We're not only setting up the trust and everything along the lines of typically what we'll do, we're actually funding them, titling it, okay? So compare apples to apples. That's the time-consuming, tedious part. And you've got the reports there, right? Okay, and so less clients, better relationships, better plans. And then the maintenance has typically been a loss leader. That's $725. You're getting a whole suite of services for that. But we have our systems down to a point now. We're in year 14 of the maintenance plan. So first few years, we were still figuring it out. We have very strong systems now. And so, we're almost breaking even on that. But the idea is, we're getting more client referrals from the maintenance plan. So that's the big benefit, I think. And also the relationship and the clients, the families always hire us. We haven't had it. Everyone has hired us in step 3. They don't have to, but we're there. It's very predictable for us. Okay. That's my business model right there. Very open. So any questions with regard to the fees? A lot of people usually will have questions with regard to that. Sometimes they don't. The one question that I do get a lot, and you might be thinking it or not, is there's two questions that people ask me, and it's usually my engineers. They'll say, Bobby, what if something happens to you? So not the people, right? What if I die, right? What if I get hit by the bus? So I have more clients worried about my health and welfare than I've ever had in my life. And I wouldn't be a good estate planning attorney if I didn't have a good plan in place myself, right? So right now, my short-term plan is I have a backup attorney who teaches with me at the National Network of Estate Planning Attorneys. His name is Ed Clay. He's in the bios that were sent out to you. And he's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his if he gets hit by the bus. And that's the short-term plan. I know Ed, he follows the same systems and processes. I've got a team in place here, and the way I do things on group format, he can do it without a major disruption to his practice. He probably wouldn't take on more clients at that point until my internal succession plan is fully developed. So right now I'm bringing on associates and bringing them up through an internal succession plan, but there's a few years away from that. Okay. The other question is that's $725. Will that ever go up? We've been doing this model from 2007. So 14 years, we've had 2 fee increases. Okay. And it's typically $50 each time, $50 to $75 per increase. So in 5 to 7 years, it may be $50 more or so. It's not going to be $1,000 more. Okay. So it's not going to skyrocket. I got to keep up with inflation and other costs and the like. Right. And so that's the 2 questions I typically get with regard to that. So be a good consumer. Ask the attorney, what are the rest? I'm a big Paul Harvey fan. So if I'm dating myself, if anybody else, he was a radio announcer that would always say, what's the rest of the story? Ask the attorney, well, what are you going to charge me for trust settlement administration? Right. And so they say, I can't tell you that. So here's my assets. I die tomorrow. What are you going to charge my family? Right. And so you know what we're going to charge. And then death tax return preparation is part of the deal. And it's becoming more and more of a need to do death tax returns with this concept called, or this tool from the IRS called portability. Again, beyond the scope of today, but that's something that where people didn't have to file tax returns before, now they do have to file tax returns. And then the trick question I always say is ask them, how do you charge for probate services? And so, do you charge differently for those assets? So the idea is if this is a trust attorney and they're going through a lot of probates, that should be a red flag to you that their trusts are not fully funded. All right. We haven't had to go through a full administration on any of our trusts. It's not a guarantee. It's just, I guess, bragging rights. We're very vigilant on the funding because I do not want to go to court on these items. So the traditional costs, I'll give you an idea. Traditional probate, remember those schedules, 2 to 5%, right? Standard living trust planning, 2 to 4%. That's that 25% discount from Florida. Our process is 1 to 2% for the entire life of the plan. Again, it's just really kind of things where just being proactive is better than being reactive. So our fees, okay? That's kind of gives you an idea of it. Hopefully that'll give you true peace of mind. There's nothing hidden behind it. And so this is the thing that when you want to look at is the whole kind of iceberg, is what I call it, like the tip of the iceberg. And so what people do on this side is, you have your traditional planning, where I call the modern approach, which I basically introduced you. The traditional planning is basic documents and questions are answered, okay? The modern approach is so much more, right? It's the counseling, it's the funding, it's the maintaining, it's the updating, it's education, it's being there for a disability or being there for a surviving spouse to get them through the worst time of their life and the settlement, right? And so it's the whole picture. Our process is as follows. So the next steps, if you are interested in exploring working with our firm, is we have Michelle, you tell Michelle or she'd reach out to you. And the next meeting would be a discovery dialogue. So right now you're here with me. It's about an hour and a half. And there's no charge for this. I'm just giving you the overview process, how we charge clients, how we work with clients, the key issues. The next meeting would be a discovery dialogue with our associate attorney, Wendy Masimer. She would review there's no charge for that meeting. She's doing it through Zoom now. She'll review your personal, it's usually about an hour to 2 hours, just depending on questions. She'll review your personal information form. She'll do a goal exercise with you. She'll answer any questions you have. She'll give you a fee, she'll give you the fee ranges and tell you what you're looking at for fees. And then if you're ready to go at that point, we could have the engagement done. That's the initial interview. That's the engagement letter, specific quote. It's a flat fee type of engagement. Go over all the scope of the services, exactly. If you need to think about it, that's why I draw the line there. Think about it. You come back, initial interview. The design meeting, that's usually, in the initial interview, we'll go through all the maintenance and all the services we provide. The counseling design meeting ranges anywhere from 2 to 4 hours. I would never keep you, on a call or in a room for 4 hours. We break it up. To me, this is the important part, where we want to make sure that's that trip to the eye doctor where we lay out and go through all of your options and in your instructions. And then after that is the delivery and review meeting. That's where we'll go through all the legal documents, make sure you understand them, answer any questions that you may have. We've been doing a lot of these through Zoom. And then we just have signing meetings. Or if you're going to come in for the delivery and review, we'll sign them there. And that's delivery and review meetings, usually 2 to 3 hours, just depending on questions. Financial strategy meeting is where we want to make sure that the estate plan is coordinated with the financial plan. Okay, so a lot of attorneys will stop there if they make it there. Then it's the estate plan coordinating with the financial plan. So that's where we'll go through all of your assets. We'll have that asset report and we'll make recommendations on here's how we would title it. Hey, what if there's a long-term care issue? If you have your advisor there, we can talk through those things at that point in time. And then once everyone signs off, says, yep, this is where everything should go, then we have the funding meeting. Our funding coordinator will have all the magic forms for you to sign to get everything into the trust. Let's close the deal, right? Let's finish it all. Let's get it done. And then there's an optional family meeting. No additional charge if it's done within 1 year of signing your plan. I'll go over the plan as high level or as detailed as you want with whoever you want. That can be done by Zoom or live, however you want to do it. And then you're just on maintenance. Okay, that's our maintenance plan. I went through that before. So that's our process. You're right here. A lot of people ask me, how long does it take to get the documents in our hands? If you're motivated, it's usually, we like to do like 2 weeks between meetings. So within like 6 to 8 weeks, you'll have documents in your hands. The funding process takes longer, but you'll have the legal documents. And then we're getting, we got to get stuff back from the courthouse or the financial institution. So that takes a little bit longer. And that's where we check those things off. Okay, so that's our process in a nutshell. Let me see how I did with the questions. Hopefully you got some decent learning today. And let me go through the questions that I would be asking and see, at least you understand why we ask it. So first question I would ask the attorney, please tell me about your interest, background, and experience in the planning field. What percentage of your practice is in estate planning? Like I told you, ours is 60 to 70%. This is what we do. How do you define estate planning? Remember that definition: control while healthy, plan for me and my loved ones if I become disabled, give what I have to whom I want, when I want, the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. The counseling philosophy, that's that pyramid, right? First get to know you, then start presenting strategies once we understand what the lay of the land is. I just showed you our process. I find process produces predictable results. What's your process for working with me? How will you counsel with me to design my plan? The way I do it is through visuals and stories. And so, I can talk through the legalese if we want, but most people don't like that. How do we assure my assets are controlled by my instructions contained in my planning documents, right? That's the important one, right? That's the funding. Who's responsible, you or me? So for our firm, it's us, but you'll find that's not how it goes in most firms, okay? There's an additional charge for that. How do we ensure that my plan stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family in the planning process? Every family is different. I prefer more involvement is better, but again, we have to, at least they need to know, whoever the people are who are in charge of the backups need to know what to do at the right time. How do you charge for services? Specifically, how much will my estate be charged after I'm gone? I probably gave you more than you ever wanted to know, but be a good consumer. Those are the fees. Those are the numbers. If they're a living trust attorney, what is your record with regard to probate? That's that trick question. What percentage of your trust-based plans wind up having assets probated? That's a mess after death, right? We don't want that. We don't want to go through court. Do you charge differently for those assets? Do you handle the filing of the death tax returns? Yes, we do. If so, how do you charge for that? That's part of our deal. What if something happens to you? That's my succession plan. How do I prepare for our consultation? That's that personal information form that we have that you should have gotten. What type of service should I expect from you? I'm a big believer in you're going to be working with everyone on our team. Everyone has core competencies. You've got the value of the whole firm behind you. Like Ginny's great with the funding. I'm great with the counseling and the legal side. Wendy's great with the amendments and the drafting. And the settlements. So everyone's got a great role. Everyone's really good at what they do. You're getting a better team. Do you expect any commitments from me? Complete the personal information form, right? So hopefully today, some of the things you should be thinking about before you go into the meeting are, what was more important to me? What are my plan goals? Am I more worried about disability? Am I more worried about minor kids? Am I worried about asset protection? Those are things that I'm trying to get an idea. And then who will fulfill the necessary helper roles? You don't have to come up with the end solution, but the idea is to think of some candidates. And I think the attorney's role is to help you pick the right candidate for the various roles. Healthcare agents, right? Healthcare agents are people who are going to ask the doctor the tough questions, who are going to honor your wishes and be a patient advocate for you. Do I have a current inventory of assets? What advisors can I involve? If you have a financial advisor, those are great to involve. Okay. So those are the main things. That is it. I think I've gone right up on the 1 hour and a half. If there's any questions, go ahead and unmute yourself if you can. Let me see. I think you can. I think you can if you want. If not, I will stay on for you can type something in the chat box. I will stay on for about another minute or so, and then I will conclude. Excellent.
Hey, Bobby, this is Andy. I have a question, and it may be a bit of a naive one. We spent a lot of time talking about estate planning and that sort of thing, but does in funding the trust and establishing the trust, but does this also cover just drafting a will as well?
Yes. And so it just depends on your specific situation, where in the discovery meeting where, it depends on which is going to be the centerpiece of your plan. So typically what happens is typically most of our clients will utilize a trust, but there's a will called a pour over will that is drafted. Okay. And for clients with minor children, right, the will list the guardians there as part of that. But yes, it's just not the will is not like the primary.
No, I did. It was the minor piece and the guardian piece that I was particularly interested in. So thank you.
Yeah, you're welcome. And then another question I got, is this recorded? I don't know if I recorded this one. I do have a recorded version of this, so I can send that to you if I didn't record this one. I always forget which one we record. I don't know if I record all of them. It'll just keep up too much space in our cloud. But if you do request it from Michelle, she can send you the latest one that we have. Okay. You're welcome. All right. Any other questions? Very good. I'll hang on for about another minute and then I will go. Hopefully you got some good education today. And if you are interested in working with us, that's great. We're motivated to help. I think we got something special here. So.
Hi, Bobby. This is Susan Villela. How are you?
Good. Nice to talk to you.
Thanks. Thanks for your presentation. So I just wanted to know what's the next step to take?
So the next step, great question. So the next step is if you reach out to Michelle, say you want to schedule a discovery dialogue, she'll get you scheduled with Wendy. There's no charge for that meeting. It'll probably be a Zoom meeting unless you prefer to come in.
Okay.
And then you'd fill out the personal information form that should have been part of the packet, or Michelle will get that to you so that Wendy can evaluate your specific situation. And then she'll do a goal exercise with you. She'll look at answer any questions. She'll give you specific fees, and then
oh, great.
That's the next step.
Okay, good. All right. Sounds good. Thank you.
You're welcome. Good questions.
Well, it was very informative, and thank you very much.
You're welcome. Have a good day. I'm going to close down now.
Okay.
And sounds good. I will stop my share and I will end it. Thanks, everybody.